Sri Lanka's parliament appointed a select committee on Wednesday to investigate the impeachment motion accusing the country's Chief Justice of misusing power and having unexplained wealth. Chief Justice Shirani Bandaranayaka denies any wrongdoing. Mrs. Bandaranayaka has said she can easily refute the allegations. She also has said she will continue to discharge her duties without fear or favor and independently, impartially and fearlessly in accordance with the law. The impeachment attempt follows months of conflict between Parliament and the judiciary. Attorney Saliya Peiris, Director of Academy of Legal Studies, Center for Professional Studies and Eisenhower Fellow, joined with Boston Lanka to talk more about this. Attorney Peiris, what is your general view about the independence of the judiciary and the threats for its independence from the executive branch?
Yes, I think there are over the years, since the inception of the 1978 Constitution, there have been in various instances, there have been threats to the independence of the judiciary. From the time of the introduction of the 78 Constitution and even prior to the year 78 Constitution, when the Chief Justice Victor Tennakon retired and there was a new Chief Justice appointed, Chief Neville Samarakot, the second most senior judge in the Supreme Court was overlooked. From that time onwards to the present day, there have been instances where there have been issues relating to the judiciary. But in the last 1 year, we find that in Sri Lanka, suddenly there has been a spate of attacks and interferences on the judiciary. Firstly, we know that there is at the moment a case in the Court of Appeal where a minister is charged with having attempted to interfere with the Mana magistrate and the Secretary of the Judicial Service Commission. We know that there was an attack on the Magistrates Court of Mana. Now, in this aftermath, the Judicial Service Commission issued a statement. Sometime in September, the Judicial Service Commission issued a statement saying that there were attempts to interfere with the workings of the Judicial Service Commission. Now, the Judicial Service Commission is important because it is the body which regulates and controls the minor judiciary in Sri Lanka. So, the magistrates, the district judges who are all over the country, their discipline, conduct, appointments are all controlled by the Judicial Service Commission. So, if there is interference with the Judicial Service Commission, there is a risk that at the lower levels, that the magistrates and the district judges throughout the country will be affected. Now, following this, the Judicial Service Commission making this statement, we know that the Secretary to the Judicial Service Commission, who acts on the instructions of the Commission, Manjula Tilakaratne, he was subject to an assault. Now, thereafter, there has been a spate of attacks on the media, especially by the state media, where especially the Chief Justice has been targeted. It is clear that there is an interference with the judiciary in Sri Lanka by the executive branch, and I think that's a very serious matter for all Sri Lankans. It's a very extremely serious matter for all Sri Lankans, because if you find the judiciary being interfered with, today it can be by the present day executive, tomorrow it can be by the executive of another party.
I'm sure you have a time to go through the charges in the impeachment motion against the CJ. Do you think at first glance those charges are sufficient to bring an impeachment motion against the CJ?
I do not want to refer to the individual charges at present, because I think that those would be replied to at an appropriate forum. But suffice it to say, the Chief Justice has, through Mr. Kandaya Neelakanda, attorney at law, informed the media which published the purported charges. She has stated her position, and I think it has been a very categorical clarification, and she has set out her position. If one refers to the statement of the Bar Association also has made certain requests from the executive and the legislature in relation to the impeachment.
In one of your articles, you write that the entire process of removal should not be a legislative function but a quasi-judicial function. There are basic attributes such as independence and impartiality. But do you think, given the fierce partisan political climate and also the powers president has, and how the ruling party MPs toe the line without any dissent, the process will be fair for the CJ?
Well, this is the grave concern of the Bar Association. In fact, I observed that the Bar Association had passed a resolution, and that resolution calls upon the legislature to bring constitutional changes to bring into place another mechanism. The reason is this: the whole impeachment process, the parliamentarians are expected to play, as you quoted me, a quasi-judicial role. Now, quasi-judicial role necessarily means that people who are hearing a case must be impartial, they must be independent. Now, in the whole impeachment process in our constitution, the weakness is that you find members of parliament who are sitting in form of judgment. Now, would they be subject to pressures from their own political parties? Can they be independent from their political parties? In Sri Lanka, we have seen, now unlike in certain other countries, we see that parliamentarians generally toe their party line. So now in those circumstances, we have a grave fears as to whether these matters which ought to be there, independence, impartiality, will be found when the select committee conducts its inquiry. Now, to give you an example, in India, a judge can be impeached by a resolution of the two houses of the Indian Parliament. But before the Indian Parliament passes a resolution, a committee has to conduct an inquiry. And the committee, it's a 3-member committee which is appointed to conduct a inquiry. And those 3 members are not parliamentarians. They are qualified jurists, a nominee of the Chief Justice, a nominee of the High Court judges among the Chief Justices of the High Courts of India. Now, it is only after they conduct an independent and impartial inquiry that the legislature would be able in India to impeach a judge. So I think it is time that we revisit our constitution and ensure that this independence and integrity of our judges are safeguarded.
Senior lawyer Saliya Peiris travelled with Chief Justice in her car to the Parliament, who appeared for her along with President's counsel Ramesh De Silva. Attorney Saliya Peiris spoke to Boston Lanka when he was in USA about the impeachment motion against the Chief Justice. He was not retained to represent the Chief Justice when he spoke to Boston Lanka. Attorney Peiris, if I'm not mistaken, you have referred in one of your articles that there is a grand plan to crush what those in power see as a judicial dissent. Why do you think like that?
Let's put it this way, in my article, I didn't say there was a grand plan. I said people might think there was a grand plan to that the people in power are trying to crush dissent in the judiciary. So I think, I don't want to say there is a grand plan, but let people who know and people who study the history of the last many years, but especially during the last 3 months, I think intelligent people can come to a conclusion themselves whether there is a grand plan or not.
According to the Constitution, Parliament needs 113 votes to remove the Chief Justice. Now the impeachment motion already has 117 signatures. So in other words, 117 members of Parliament accuse CJ with all these charges, and they are the ones who will be voting in the Parliament to pass the motion. Don't you think this is a little bit comical or tragic? CJ's fate has already been decided. Do you agree?
I do not want to comment on the parliamentary proceedings, but once again, in the normal process we are used to, the judicial process, you find one party accusing, a different party judging, a third, so what you might find in a normal criminal case, the Attorney General or the police might make the accusations. There will be an impartial judge who tries the case, who listens to the evidence and comes to a conclusion. I must say I have my grave concerns when the accuser also judges. I have my grave concerns.
According to many members of the legal profession, the Sri Lanka Bar Association has been very ineffective in protecting the independence of the judiciary. Some senior lawyers in Sri Lanka has gone on record saying that its leadership has no backbone to stand up for the independence of the judiciary. What do you have to say to that?
I think in all fairness to the President of the Bar Association of Sri Lanka, Mr. Vijaydas Rajapaksa, I think what he has been trying to do is to get all parties to come into some common ground when decisions are taken. Now the problem when we try to say common ground is there are people who come to the Bar Council or the Bar Association meetings and they come with an agenda, with a political agenda of their particular party. Now this is the problem which I think it is not only the Bar Association but many organizations face. There is a deliberate attempt to undermine the independence of these institutions. So just as much as there has been an attempt to undermine the judiciary, I think there has been an attempt to undermine the independence of the Bar Association. So you find that people with political agendas come in and try to take the bar on a course to suit their political ends. Now this is very unfortunate because over the years, if you look at the history of the Bar Association has had a history of being independent, of raising issues without fear, without favor, not being frightened of the government. At the same time, taking an independent stand. You have found people like Mr. H.L. De Silva, President's Counsel, who it was known that he used to appear for so many cases of the government, of the SLFP. He would take an independent stand. Mr. Ranjit Abesuriya, President's Counsel. They found these are people who took independent stands. I think one of the most eminent presidents of the Bar Association we have had was Mr. Desmond Fernando, who was fearless, as well as Mr. Ramesh De Silva. So, President's Council. So all these, the presidents of the Bar Association have taken an independent line. I don't wholly blame the present office bearers of the Bar Association, but I think the Bar Association has to be more decisive. It should be more decisive and you can't delay. There are certain decisions which have to be taken promptly. Otherwise, there will be criticism of the Bar Association.